Thank you, Honorable Speaker, for this opportunity to give my exposition on the statement on the legislative proposal to amend the Constitution. And Honorable Speaker, before I start, let me thank you for having facilitated through the office of the clerk for us to be able to reach at this level within a record 1 month. And let me also thank members of this House for overwhelmingly supporting the legislative proposal, which only required 50 members to sign. But the last time I saw the list of the signatories, members had already reached over 300. That is very, very appreciated. And that means that actually we are in this game together. It's only that we are just taking the lead with Honorable Mule, but I know this is a matter that is at heart of each and every member. Allow me, Honorable Speaker, to take members through the legal and constitutional framework surrounding these amendments. Honorable Speaker, Articles 255, 256, and 257 usually give the procedure and the instances in which the Constitution can be amended through a parliamentary initiative or a popular initiative. In the present case, Mr. Speaker, we are talking about the parliamentary initiative. And members, according to the Constitution, Parliament can amend any part of the Constitution, but the procedures for amendments through a parliamentary initiative is usually two-pronged. One, whereby you amend the Constitution and you end up to the referendum. The other roadmap, you may amend the Constitution and you don't need to go through the referendum. And that is what I wanted to enlighten all to enlighten members on. Under Article 256, where Article 256 grants Parliament, both levels of Parliament, that is the National Assembly and the Senate, either houses of Parliament can initiate a constitutional amendment. And we have initiated one in this House. And after the publication of the bill, the House or the bill will be read for the first time in this House, and it will require that we have a whole 90 days for the public to weigh in, for public participation, before the matter is reintroduced back to the Parliament for the second reading. And in both instances, that is the second reading and third reading, the threshold to pass a bill to amend the Constitution is 2/3 majority in both houses. If both houses pass the bill, then the two speakers of the National Assembly and the Senate will pass the bill to the President for assent with a certificate. However, the President will not assent to the bill if it touches on the matters that are enumerated under Article 255(1), which, if the bill touches on the matters of Bill of Rights, the sovereignty, the supremacy of the Constitution, independence of the judiciary, and commissions and independent offices, and other matters that are enumerated there. In that instance, that bill will stand committed to the IBC by the President for them to give an approval for his assent. And that approval will not come until the matter is taken for a referendum. And the requirement in that referendum is that at least 25% of the registered voters in more than half, in half of the counties shall have voted with a majority of the members giving a nod to the bill. That is when the President will, the IBC will give a certificate, and the President will then assent to the bill and have it published. However, in our case, we have tried to avoid that route, because we have avoided to touch on all the matters that are enumerated under Article 255(1), whereby we are not touching on any one of them. So our case is that this matter will end up with both houses of Parliament. Then both speakers of Parliament, should we reach the requisite 2/3 majority, will present the bill to the President for assent. And Mr. Speaker, on the matter, on the roadmap that is provided under the standing orders, as you've already guided this House, today we are not debating this bill for any vote or for any resolution. We are just giving the House an opportunity to give general comments, which will later be collated and taken into account by the committee that will be given the responsibility to take this matter forward, which your Honorable Speaker has already given, that NGCDF committee will be steering further discussions in the matter. Honorable Speaker, and for the interest of the members, towards the tail end of the Parliament, the Procedure and House Business House Rules Committee, which is under the leadership of the Speaker, presented to this House the amendments to the standing orders, and that is how standing order number 114.7A was introduced in this House, because of the importance of constitutional amendments. The roadmap towards an amendment of the Constitution was given preference in that amendment. And one of the areas, or actually the first step, is to have a legislative proposal, which we've already have before this House. The Speaker has already allowed members to make, or the sponsors to make statements, which we are already making, so that members can weigh in and give their general comments. Then after this, these comments of the members, there will be a facilitation for collation of these comments. And that is why we are urging members, kindly, if you can give your views as to how we can be able to enrich these amendments, that will be the best thing, because they will be picked by the committee that will take over the matter from here and be able to guide the House ahead. Then after the collation of the comments, the committee will also give members another opportunity to appear before it, and the other stakeholders, including the AG, the commissions, and the independent offices, and including the Senate. And this, Honorable Speaker, thank you, have given a very good guidance. There were fears by the senators that we might discuss and pass this bill as it is before their input. They will have an opportunity at the next level to give their views, and any other person interested. The whole country will also have an opportunity, because we will have a whole 3 months after the first reading for us to be able to reach out to every other part of this country, being a constitutional amendment. Mr. Speaker, lastly, after all this is taken, there will be what we call harmonization of all the views that have been collated from the views from this House, from all the stakeholders, and at that point, that is when the bill will be published for first reading and introduction into the House. At that level, Honorable Speaker, with your guidance, that is where you said that once the bill is introduced and read for the first reading in the House, it cannot be amended. And that is why this roadmap, this period is very, very important, so that all people that have an interest in the matter can be brought on board. Without belaboring the point, Mr. Speaker, this is an opportunity for these members now to give their views, to give their comments, and reach. Please do not kindly members. We have not done this in finality. So we beseech you not to seem to be like you're correcting us. Appear to be like you are enriching the debate, you are enriching the proposals that we've come up with, so that we can have the best for this country. We protect CDF, GAF, and introduce 2 other funds which are very critical in this country. As I wind up, Honorable Speaker, let me also give some insight in the matters that were in court. The first matter that was in court was the one that was challenging CDF Act of 2013, not NGCDF. Those are 2 different funds. CDF is the one that had been introduced and was overlapping with the functions of the counties. And the Supreme Court said that the CDF Act was offending the Constitution because it was actually purporting to perform some of the functions of the county. The other reasoning of the Supreme Court was that the way it was couched, it is like CDF was meant to dip into the jar of the consolidated fund and get money from there, therefore creating a third tier of government. I think to some extent, agree with some of their reasoning. But now, in the wisdom of this House, NGCDF Act of 2015 was enacted. That aligned the fund with the national government functions. And I believe we have a good case in the High Court. There is a High Court case number 178 of 2015, Honorable Speaker. I will not give comments on it. Otherwise, I would be taken to have gone against the rules of this House under the Standing Order number 89, the sub judice rules, because this matter is active in court. It is alive. It has I'm informed by the litigation department that this matter has a date for submissions on the 1st and 2nd of December. Thereafter, judgment will be given. Honorable Speaker, I rest my submissions, and I urge these members to support our statement and move this country forward through the support of the poor, the poor parents, the poor children who cannot otherwise access education without bursaries, which is also stemming from the NGCDF. Thank you, Honorable Speaker.
Honorable members, you've heard the proponents of the bill, the proposed bill in its pre-publication stage. What follows now is not debate as such.